We have one case before us this morning for video oral argument, and it is Kalvyn Stull et al. Versus Summa Health System et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time, please let me know when you get started. I'm keeping the clock this morning. We have read the briefs and we are ready to proceed when you are.
All right, may it please the court, Stephen Funk of the law firm of Retzel and Andrus on behalf of Summa Health System and all of the appellants in this appeal. I'd like to reserve 3 minutes of my time for rebuttal. The sole issue presented in this appeal is whether the trial court erred by compelling the production of the entire residency file of Dr. Mazen Alashi under the peer review privilege that's set forth in Ohio Revised Code 2305.252. And that is a question of law that is subject to de novo review because it turns upon whether the trial court applied the correct legal standards in determining whether the entire residency file was privileged under the statute. Now, it's important to remember that this document request, the only document request that's an issue in this appeal, is request number 25, which asks for the production of the entire residency file. And in their motion to compel, they only sought the production of the entire residency file. They weren't seeking specific other documents or records. So the question presented before the court is whether Dr. Alashi's residency file falls within the scope of a peer review committee under the statute. And this court has established a two-part test for making that determination. The first part is the healthcare entity must establish that the existence of a peer review committee as defined by Revised Code 2305.25E, and then second, establish that the document at issue, which in this case is the residency file, is a record within the scope of a peer review committee. And to make that proof, Summa submitted affidavits that first clearly established that they had formed and created peer review committees that were designed to oversee the evaluation and quality of care provided by resident physicians, and specifically created a graduate medical education committee that was responsible for the evaluation and quality assessment of resident physicians. And then the GMEC, in turn, created a second group of peer review committees that were called the clinical competency committees, and there was one established for each residency program. And those committees consisted of the residency director and then all the physicians in that particular that had clinical privileges at Summa, who were members of the faculty for the residency program and who participated in the peer review processes for the medical care provided by residents at Summa. So there was no real question that there is in fact peer review committees created. The next question is the second part of the test is whether the record falls within the scope of a peer review committee. And in that regard, Dr. Lepley's affidavits set forth specific facts that were designed to show that this was in fact a residency file was created by a peer review committee, used by a peer review committee, and kept and maintained by a peer review committee. So first, her affidavit explains that the residency file contains information and data that was gathered by the GMEC for use by the clinical competency committees to conduct quality review of each resident and to make recommendations to the program director and the GMEC about quality assurance, the status of the residency program, and the competence and professional conduct and quality care provided by residents. And in that regard, her affidavit explains that these records are kept by the graduate medical, the GMEC, I'm just going to use the shorthand for that, and was strictly limited to those individuals who participated in residency review and peer review processes. So this affidavit explained what a residency file was, why it was created, how it was created and used, and how it was kept and maintained. So it clearly is a record of a peer review committee, and that's why it falls within the scope of a peer review committee under the statute. And as we set forth in our brief, there's a number of cases that have held that a record.
Also, I just want to interrupt, excuse me, I want to interrupt you just to make sure I completely understand what's going on here. So there was no in-camera review requested or done, right?
That's right. And this court has held, and all the courts have looked at this, said that there's essentially that could either be an in-camera review or by affidavit. There's no requirement for an in-camera review.
Okay, so obviously as you indicated in your briefs, and the hospital is actually claiming that every single document
in this residency file is subject to the peer review committee. I mean, that it's subject to that, I can't even think, privilege.
So Your Honor, the record request that was made was for the residency file. So our position is that the residency file itself, and basically then by definition, then all the documents within the residency file is a record of a peer review committee. And that's the key thing I think that this court held in Casino, I'm sorry, the 6th District held in Casino, this court held in Hammond v. Ruff, that a record of a review committee is subject to absolute immunity from discovery under the statute, regardless of the author or source of the documents. And in this case, a residency file is very similar to the credential file that was at issue in Hammond v. Ruff. And that's because, residents are not fully licensed physicians, so they are subject to, they're not subject to credentialing at that point in their process, but they are subject to peer review pursuant to the peer review processes at Summa. And so a residency file is very much like a credentialing file. It's a file that was created by a peer review committee for purposes of evaluating the competency and professional conduct of resident physicians, and it's kept and maintained by a peer review committee. And so therefore it is within the scope of a peer review committee, regardless of the author or source of each of the documents. And I think that
So excuse me for a minute. On that issue with the residency file, obviously residents are doctors, but not, full-fledged doctors yet. They're still in some aspect of training, certainly some aspect of still being educated. How do you make a distinction, or do you make a distinction between a file that might contain information regarding their education and a peer review file, or do you see them as being one and the same?
Well, this file was specifically kept for purposes of reviewing the quality of care, the competence, professional conduct as part of it. And I don't think that it makes a difference in this case regarding whether it's for purposes of education. In this case, this is a peer review committee. This is a record that's kept and maintained by a peer review committee for purposes of seeing the quality of care and the competence and so obviously as part of doing the quality of care review, there is some aspect of reviewing to see how people are doing and giving their comments and that kind of thing. But it falls clearly within the definition of a peer review committee as defined by 2305.25E.
Go ahead. I'm sorry.
Are there any residents on these committees?
No, the members of the committees are the individuals who have clinical privileges, and that's set forth in the affidavit. So so when you talk about peer review, it is review by other doctors reviewing the quality of care provided by a resident. And it's no different. It definitely is a peer review committee in that sense that it's designed to ensure the quality of care, the competence, and the overall professional conduct of physicians who are practicing medicine at Summa.
I had a question, but I don't know if Judge Callahan had a question first. I'm sorry.
No, I don't. I'm done.
Okay. I just want to make sure procedurally what's going on in regard to the residency file as well. So there's a separate personnel file for each of the residents.
Well, the affidavits that are in the record they did not request a personnel file. That was not the request at issue in the case. So the affidavits do not discuss whether there are personnel files. So when you talk about personnel file, that was not the request that was made. This was a request for a residency file. A residency file is a specific type of file that's kept and maintained by the GMEC for purposes of peer review. And so that's really, I think, the key. Yeah, I'm sorry, go ahead.
No, and I am interrupting you, but we just have limited time. So I guess I want to just try to zero in on my question a little bit more. I guess my concern again is just from the fact, I know they didn't request a personnel file, but I'm trying to figure out what exactly is in this. There was no in-camera review. The judge just said, basically, you didn't meet your burden, to demonstrate that the whole file was subject to the peer review committee immunity. So I'm just trying to figure out, you know, is there anything in there that just talks about how, when they were hired, what their, you know, employment status is, what their insurance benefits are?
Well, Your Honor, I don't know that we necessarily have to get into that level of detail. And that's, I think, where the trial court got this wrong. They didn't, normally, this case is actually a very simpler issue than in many cases. For example, in the Bansal case that's referenced in the briefs, the 10th District opinion, there was a whole list of document requests that were made. And so in that situation, the burden is different in that you have to establish how each document request, whether it was part of a peer review file or if it was from other sources. In this case, they did exactly what the 2003 amendment says you cannot do. And that was explained very clearly in Hammond v. Ruff. They just went, we want the peer review file. And the peer review file is a file of a peer review committee. We want the residency file. And that's a file of a peer review committee. And that's exactly what the 2003 amendment says. It says, regardless of the source of the document, you can't just go to the peer review committee itself and say, we want the production of your file. So it doesn't matter what's in the file. It is a record of a peer review committee. And this is not a case, this is where I think the trial court got it wrong. This is not a case where you have to look at what specific documents and you're trying to figure out, this is the request for a peer review file. And that peer review file, by definition, is a record of a peer review committee. It was created by a peer review committee. It is kept and maintained by a peer review committee. So it is a record of the peer review committee itself. And that is, in many ways, a simple issue because in Hammond v. Ruff, this court specifically said that the 2003 amendment says you can request documents, but you cannot just request, we would like the peer review committee file. And that's what they asked for here. And if you can play, they want to get into semantic games about whether or not this is in fact a peer review file, but a residency file is a type of file. It's kept and maintained by a peer review committee. And that's why it's subject to the peer review privilege by definition. And I think that's where the trial court got it wrong is the trial court got into, well, what are the specific documents in the file? That doesn't matter in this case because the record request that was made was for the peer review file. And that specifically is not permitted under the peer review statute. You cannot go directly to the peer review committee and ask for their file.
Counsel, you're just now reaching that 3 minutes.
Okay, well, and I guess I want to make that point that this is in many ways a simple issue. The statute, the key language of the statute is, does this fall within the scope of a peer review committee? And our affidavits contain very specific facts that were designed to show that this file, a residency file, was created by a peer review committee, kept by and maintained by a peer review committee, and therefore falls within the scope of a peer review committee. And under Casino and under Hammond v. Ruff and Bansal and all the cases we cite in our brief, it is clear that a record of a peer review committee is absolutely immune, is not subject to production, and they cannot just simply go to the peer review committee and ask for a production of their file. So
Counsel, let me just, I know you're running out of time, but let me just ask you, what is to prevent then any document being put in there and, it's just part of the peer review committee record? So if that's the test, then anything that's kept by the peer review committee is non-discoverable. So,
Your Honor, that's the way the original source rule works is that if you make a specific document request, that's like, I want a production of this document, okay, then you can go to the original source for that document, but you can't just go to the peer review committee and say, I want your file. That's exactly what the 2003 amendment is designed to prevent. And that's what this court got correct in the Hammond v. Ruff in saying that you cannot just go to the peer committee and ask the file. So your concern is not really an issue because if you're asking for specific documents, you can get those from the original source, but what you can't do is just go to the peer review committee and say, I want your file. And that's what they did here. And that's why it's in many ways, a very much a simpler issue than it would be in other kinds of cases where you might be asking for specific documents. Like, for example, Your Honor, if they asked for a personnel file, okay, that may or may not be different. I don't know because it's not in the record, but that would be a different case than what we have here, which is a specific request for a residency file. Our affidavits explain what a residency file is, how it was created, how it was used, what its purpose is, and that it is in fact a record of a peer review committee. So we ask, therefore, that the court reverse the trial court's ruling as a matter of law, and her order compelled the production of the file. The file is subject to the privilege, and we ask the court to reverse as a matter of law.
Thank you,
I'll
counsel.
reserve the rest of my time for rebuttal.
About a minute. So, yes, thank you. Counsel.
May it please the court. Megan France Oldham on behalf of the appellee Kalvyn Stull and his family. Attorney Funk says that we requested the peer review file, which we did not. We requested the entire residency file. Whether or not, that's inclusive, right? It doesn't say we just want peer review, which we don't want the peer review information. We want the entire resident file, which would include his application, which would include typical personnel information that you would ask. We didn't differentiate where we wanted that information from. We said we want the entire residency file. And they responded, it's completely, all of it is entirely peer review, which we disagree with. The appellant Summa is asking this court to extend the peer review committee statute to a point that it's never been extended to before, to not only to a residence file, but to the entirety of a residence file. If this court agrees with that proposition, there's frankly no end to where peer review ends. It could include a nurse's file, it could include a text file, any medical provider. That information could fall under that proposition under peer review. The overarching—
Wouldn't the answer then be just for in-camera review for a court to look at documents that would fall under peer review and, just regular old personnel items, for instance?
So it could be, and I don't think we reached that point. I think one really, really important point for this court is, and you have to look at this, we all know that this is Summa's burden, right? You look at Dr. Leapley's affidavit. She makes it clear that there is this GMEC, Graduate Medical Education Committee, also referred to as the Medical Education Department. And it's this overarching umbrella that she refers to. And that one of those committees is referred to as CCC, or the Clinical Competency Committee. And she specifically discusses what that CCC committee does, Clinical Competency Committee. And she says that they're the ones that do the quality. So, I think based upon what I know, my understanding is how it works for Summa. If the residency file is only maintained, is generated for that CCC, then it would fall under peer review, but it's not. There's no evidence to suggest that, and that's what Summa's burden is. Instead, all evidence is that this resident file is maintained by GMEC, by the General Medical Education Committee. And I submit to this court that that is not peer review. Instead, that includes administrative functions, that includes things that do not fall under peer review. The overarching principle is that patients have a right to know. They have a right to know what happens with their medical care currently, in the past, and who's providing care to them. The purpose of peer review is to allow the free flow of information in very limited, very specific peer review committee processes. And here, Summa wants this court to expand what that definition of peer review is. As it is a derogation of common law, they must be limited. Instead, the overarching principle is that patients are entitled to their information. First, we asked this court that it dismiss the appeal based upon our motion to dismiss. Based upon the court's ruling, Legg versus Hallett, this is not a final appealable order. The court did not order Summa to produce its peer review information. It said produce a resident file. So we submit that this is not an issue that is ripe for appeal and ask this court to dismiss the appeal. Alternatively, we ask this court to sustain the trial court order and find in favor of the appellant on the basis that a resident file is not included in peer review committee statutory language. The closest statutory language that you will see is credentialing file, which Attorney Funk addresses, and quality review activities. This is not credentialing. This is very different. And you have to look at the affidavit and what I've referenced in terms of the GMEC and the CCC, that finite committee. That's not the information that we're asking for. Instead, we're asking for the resident's evaluation. As to what we do know that the file contains, and I think it's important to point out, Dr. Lapley doesn't articulate what information is in the resident file. We know from Bansal, the court held that the healthcare entity must, in meeting their burden, must provide evidence as to the specific documents requested, not generalities, regarding the types of documents usually contained in a peer review committee's record. And you look at Dr. Lapley's affidavit, and that's exactly what she does. It's generalities, it's quality documents without any specifics. And that's what the trial court looked at in granting our motion for compel and finding that peer review did not attach. But we have to look at what documents we are aware of that are part of that residence file based upon the testimony that we have. We know from Dr. Alashi that it included evaluations and that he would receive a copy of those evaluations. He'd receive a hard copy and he would also have access electronically. As Attorney Funk admitted in his argument, he was not a member of the peer review committee. And whenever you have someone outside of the peer review committee accessing files, it either destroys privilege or it never existed to begin with. So here we have hard evidence of documents that are not only contained within that peer review committee structure, but other people have access to. We also know, based upon the testimony as to what documents are in that resident file, there's something called step 1 and step 2 testing results that were done in part by respiratory therapists. No evidence that they're part of the peer review process. That's something that is submitted. We also know that part of what is in that resident file are numbers of intubations that the resident did. And that information is in fact inputted into a third party's website, into the ACGME, which is a third party. And we know from Huntsman out of the 5th District, 2008, that when information is submitted to a third party, a non-hospital like the Joint Commission, or in this party, the, I forget the acronym, the third party, when it's submitted to them, that it destroys the privilege. That submitted to third parties, non-hospital like Joint Commission with no evidence of having a peer review committee, that information is discoverable. So here, based upon the documents that we know, there's evaluations that are completed by an attending at the end of each resident's rotation, and the resident receives a copy of, and they're allowed to do what they want with it. Dr. Alashi testified he often throws it away. There's no information to suggest that they're not able to do what they want with that. We also know that there's submissions that the resident can perform certain procedures, such as intubations, which are at play in this case, evaluations of the residents performing intubations, those step 1, step 2 test results, and the number of intubations performed by the residents. And that's what's submitted to the ACGME, a third party. So we submit that based upon what we know is in the resident file, it certainly does not attach to any sort of peer review, instead is outside of the peer review process. It may be reviewed by this CC committee, but that does not make it peer review. If it's available by another source, which is the resident file, then peer review doesn't attach. And we know based upon the case law that just by labeling something peer review, it's not sufficient, right? Dr. Lapley, Attorney Funk can say peer review all they want, but just by labeling something peer review does not make it peer review. The court in Selby said that an affidavit's not sufficient. The court in Smith versus Cleveland Clinic said an affidavit is not sufficient, and said you have to actually look at when information is provided and whether or not that very limited privilege attaches to the information at issue. And we submit in this case, it does not. In terms of the peer review statute, we know it does not include residence file. You look at the statutory language of 2305.252, it doesn't say resident file. It says credentialing and quality review activities, which we submit has not been met here based upon Dr. Lapley's affidavit and based upon the fact that this information is available from sources outside of the peer review committee. For example, those employees such as Dr. Alashi that have access to the documents at issue for non-review purposes. Looking at the present case. So first, as Attorney Funk kind of briefly addressed, you have to look at whether or not peer review committee exists and whether or not they investigated the incident. In this situation, we know that peer review did actually investigate what happened to Kalvyn. It was peer reviewed by internal medicine, and it was peer reviewed by surgery, both on July 20th, 2018. That's not the documents that we're attempting to get, right? We're attempting to get the resident file of the intern resident that was permitted to attempt to intubate Kalvyn when he was in an emergent situation and had been in respiratory distress for an extended period of time. And Dr. Welko, the attending who came in after the fact, testified it was a breach of the standard of care to allow Dr. Alashi to attempt to intubate Kalvyn for the very reason what happened to Kalvyn. Dr. Alashi intubated him incorrectly. It went into the wrong place. It went into his esophagus instead of his trachea, which delayed his ability to receive oxygen. Approximately the fourth time, he was finally re-intubated, but at which point it was too late and he suffered a cardiac arrest, is now in a vegetative-like state for the rest of his life. So the issue is, was Dr. Alashi allowed to perform that procedure? You know, we don't know. We don't have any documents to support that he was or was not because they're claiming review. Were they on notice that he could not intubate correctly? You know, we don't know. We don't know because they're claiming this broad privilege over his entire resident file. Quality review activities. What does that include? What does it not include? We know it does not include an impromptu conversation between providers soon after an incident. This case, the one before, the trial court ruled, Summa attempted to argue that an impromptu conversation between Dr. Alashi and Dr. Blecker was peer review. They made that argument to the trial court and said that we weren't entitled to that impromptu conversation as to what was said. The trial court disagreed, ruled that we were entitled to that information, and Summa decided not to appeal that. But we know it not only from this trial court, but also from this court's ruling in Gisty, 2008, which held that there was not sufficient evidence that the conversation between two doctors was a part of the peer review committee process. So there you have a conversation between two doctors as to what happened. Because it was not within that peer review process, the plaintiffs were entitled to that information. So where does that extend? If it's memorialized, if that's documented, is that something that also is not protected? And I would submit yes. Privileges being in derogation of common law are obviously to be strictly construed. And we discussed that the healthcare entity must provide evidence as to the specific records requested, not generalities regarding the types of documents usually contained in a peer review committee's records. And the trial court at page 14 of its opinion, that's exactly what they cited to. They said Dr. Lapley's affidavit contained mostly generalities and conclusionary opinions. She does not identify any specific individuals who authored documents contained in Dr. Alashi's file, or specifically identify any individuals as being part of the peer review process. And they point to evaluations by Dr. Blecker, who admits he was not part of peer review. They point to evaluations by Dr. Porter, the program director. There's no evidence he was part of peer review. And evaluations from a respiratory therapist, who Summa has provided no evidence that they are part of peer review. In addition, we know that Dr. Alashi is not part of the peer review, and he's provided copies of those. The reality is they're attempting to cast this very, very wide net, which will have no end, in claiming that any document that they put in a resident's file is peer review. And we suggest to that court that that is absolutely not true. And it should not be the law, and it should not be the extension of the law. Perhaps that CCC committee, what they do, they review a resident's file, make a determination, make a recommendation. I'd submit, based upon what I know, that that is privileged, but just because they review a resident's file or parts of a resident's file does not make it privileged, right? You look at whether or not it is available by any sort of outside peer review process or outside committee, and we submit, in this case it is. We also submit, discuss the waiver issue, the fact that they allow Dr. Lashy access to these documents. It falls under this outside scope, in that there's no privilege that attaches to the documents. With that, Your Honors, we ask that this court dismiss the appeal. We did not ask, and the trial court did not order any sort of peer review committee documents to be produced. And instead they held that a residence file, the entire resident file, be produced. Alternatively, we ask this court to sustain the trial court's finding that Dr. Lashy's resident file is not protected by peer review committee privilege.
Thank you, counsel. Mr. Funk, you have a little less than a minute for rebuttal, and you will need to unmute your microphone.
Right, thank you. Yeah, I think what she's missing here is that the request that was made was for a peer review record. And so when they say we were asking for the residency file, well, the residency file, and that's the purpose of the affidavit. The affidavit explains what a residency file is. It is a type of record that is kept and maintained by a peer review committee. And we're not asking for anything more than the court to follow the plain language of the statute and the standards that have been established by all the courts in Ohio, which says if a record is a record of the peer review committee itself, and this clearly is, then it is subject to absolute immunity regardless of the contents of the record, regardless of the author of the record. And that's where the trial court got wrong, because it's not a question of whether going through each and every document within the file to see whether it was for peer review purposes, because this is a record of a peer review committee. It is by definition subject to the peer review. And by going in and saying that this was not a request, for example, for specific documents. It was a request for the peer review committee file itself. And that's exactly what the 2003 amendment was not intended to do. So the affidavit is very detailed on the two key elements that need to be established. One,
counsel, I appreciate your argument. You're making a very cogent argument, but I've allowed you to go over time.
Okay.
And so I'm going to have to ask you to just give us a brief sentence to sum up.
Okay, yeah, let me just wrap up. There is a peer review committee. I don't think that there's any dispute about that. And this is a record of the peer review committee. With those two elements alone, the court can and should reverse the court's order as a matter of law.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.